at a TPR, which is the most often time where ICWA notice reversals are coming up, because they will just remand it for proper notice, and it's only delaying issues and sometimes giving parents false hope. I can tell you the most, maybe not annoying is not the right word, but one of the hardest things is when a parent gets the notice that's remanded for ICWA notice and they think, oh, I've got another chance. Like maybe my parental rights haven't been terminated yet, and you're saying, no, sorry, we're just here to check the notices. I don't actually even need you. And your parental rights are in fact still terminated, but now we've done our job. So moving on, notice then, if there is reason to know, as I said, then the court must proceed for all future purposes as if the child is an Indian child. That means applying each and every substantive provision of the Act as if this child were an Indian child. Now, for most of us, that will just end at about the notice portion of the case, because if it turns out this child is an Indian child, it should get transferred to the ICWA courtroom. However, sometimes you don't get responses back in a timely manner. And I'll get to that when I get to the timelines a little later, what impact that can have on a case. It's very, very important that notice is done. Now, there was a recent case, ICWA, that was just filed on August 8th. We actually had 2 recent published cases on ICWA that, at least both in part, in my opinion, are not helpful to us at all. But ICWA, published on August 8th, seems to imply that we can waive, us Parents Council, can waive the right to appeal ICWA notice if it has not been raised in the trial court level. That does not mean that you can waive ICWA notice at the trial court level, because as every court has said, the tribe's right is one of the rights that's ultimately being protected by ICWA notice, and the child's right to have the tribe be a part of their case. And the whole purpose of notice is to inform the tribe. We may have one of your children. Can you confirm this or not? If we, as Parents Council, are able to waive this requirement, not submit the information to the court, because we don't really want to deal with all the timelines of ICWA notice. I really want to know time waiver, and I don't want to have to wait for notice to come through. Well, then you are, in fact, ensuring that if this was an ICWA case, the tribe will never find out. Your client will never have the benefit of the increased burdens, of the resources available to them through the tribe. And you may end up getting reversed if it comes to light. In fact, you most definitely will get reversed if it comes to light. So, while I've had a couple discussions with some people about the impact of ICWA and what this means in terms of no time waiver trials, because our interest, right, is for our clients, for moms and dads. And we sometimes have a case where it's really right for a no time waiver. However, notice is fundamental to due process, and whether it's ICWA notice or notice to a parent who has a right to be present, notice is required. And unfortunately, there's nothing that I can say that would necessarily give you the right to just ignore notice, ICWA notice, or any notice and go forward with a no time waiver. What I would urge is that at detention, if you think you want a no time waiver, which is when you would suggest it anyways, you are urging the court to order the department to send its notices immediately, because the notice timelines actually say that no hearing, and particularly adjudication, may proceed until at least 10 days after receipt of the notice by the parent, Indian custodian if one applies, tribe, and the BIA, which is the Bureau of Indian Affairs. So theoretically, if at detention, ICWA is brought up, you say, my client indicates that they are a member of the Cherokee tribe, or they have some heritage in the Cherokee tribe through their grandma, and grandma's name is Rose, and she can be contacted at this telephone number. Then the department should be ordered immediately to begin preparing their notice documents, that's the ICWA 030, and sending those out so that hopefully by the no time waiver trial, whether it be the 15 or 30 days, your notices are proper. And if not, hopefully at that point only a brief continuance will be necessary instead of, oh, we haven't even sent out ICWA notices yet, okay, now we need to send them, get the information, and it's going to be another 10 days from when they're actually received. Has anybody, or have you guys seen the ICWA 030 forms in your cases at all? Do they come up? In case you're not familiar with them, I just printed out, they're lengthy, so I just printed out a couple examples instead of giving everybody one. Because I don't like to waste paper. These are the forms that I'm talking about when I say notice. So the forms we fill out are just the inquiry portion. We are not required, although some courts will try to make you, fill out the ICWA 030 form. I actually put in there the rule of court, 5.481B. It's actually also A, which indicates that this form and the information within it is to be done by the social worker. It actually mandates that the social worker interview relatives, anyone who may have information to know that this child is an Indian child. They're supposed to reach out. If a parent says, my great-grandma Jean and my grandpa John might know something about it, if they can provide a telephone number, great. If not, the social worker should be contacting other family members. They should be doing this inquiry to find out if they can get the information to fill out the form. Now, the ICWA 030 forms require that the social worker include information from the biological parents, grandparents, and great-grandparents. Lately, I've seen, at least in my court, the social workers have been attaching family trees to the reports in addition to the 030. It's actually quite helpful. And it gives you a nice little framework to go over with your client. Because although it's not our responsibility, best practice is to go over the details in the form with your client, because sometimes they're the one with the best ability to verify the information or not. For example, I had an ICWA case, which unfortunately I was not happy that it was getting continued over and over again for notice, and at one point the court was ready to set it for an OSC race sanctions. The first time we went over the notices and grandma's name was spelled wrong. That seems very small and inconsequential. However, the tribes who are getting these notices are getting, I don't know, hundreds, thousands of them, probably a month, and from all over. And they just run the information through a system of theirs. And it's just like if we have a misspelling and we try to run a name through JCATS, are you going to get the case? No. If you don't have the client's name spelled right, it's not going to come up, and we're going to think that we don't have a case by that name. Same with the tribes. If there's a misspelling of a name, type 1 a birth date, registration number is very important. Type 1 a registration number. Those things are going to be the most important things for them to identify your client or your client's child as a member or eligible for membership in the tribe. The notices, if I haven't said this already, obviously must be written on the 030 form. The rule of court indicates everything that must be included with that notice, which often we don't see in our copies of the reports, but should be in the court file because the social worker is required to provide, to submit proof of the notice and everything that was sent with it. to the court file. That includes a copy of the petition, an advisement of their rights, the tribe's rights to intervene, to participate, the timelines. Again, very important, because the tribe has the exclusive right, no one else, no judge can determine if a child isn't eligible for membership in an Indian tribe. And these things are often changing. So just because a child at one point was not a member or was not eligible for membership, when a case was originally open, you had a 300 petition, you filed your ICWA form, they did the notices, it turned out the child was not eligible for membership, was not a member, it closes out, it comes back in. Do we do new ICWA notice? Absolutely. A lot of courts will say, no, it's reactivated, we previously made new ICWA findings. No. New ICWA notices need to be sent out. A new ICWA form needs to be filled out, a 020. If your client has new information at that time, great. If your client has new information that says, actually, I was wrong, I don't have any information that I have connection to a tribe, then maybe notices are not required. But every time a new petition comes in, new notice should be sent out, because these things can change. So now we have our timelines. Now, notice, I'm going to talk about it in terms of two separate timelines. You have your adjudication hearing, which cannot proceed until at least 10 days after notice has been received, as I said, by the parent, Indian custodian if one applies, and the tribe and or tribes, and the BIA, the Bureau of Indian Affairs. Now, that is certified or registered mail, return receipt requested. Sometimes we don't get those green cards in our copies of the reports. You gotta check the court file, you really do. You gotta check the stamp, look at it. Has it been 10 days? If it's been 10 days, great. Go forward on adjudication. Does that mean this child is not an Indian child? No, not yet. As far as the court is concerned, this child may still be an Indian child, so all substantive provisions must be applied. However, adjudication has no differing substantive provisions. So after 10 days, go forward on your adjudication as you would in any other case. Then the issue becomes disposition. Now this has been, I think, an issue of contention for some courts, and there's a lot of pushback in the delay that this may create. And I'm sure that there will be a lot of pushback for you in the interest of your clients in the delay that this may create. However, the court, unless there's been a determination that a child is not eligible, is not an Indian child, as I've stated, the court must continue to proceed as if this child were an Indian child. Now at disposition, that requires a higher burden, a different standard. So if you haven't heard back from all the tribes, you're at disposition, it's been past the 10 days, but you're still within 60 days of receipt of your green cards. It still is, for all intents and purposes, possibly an ICWA case, and requires qualified expert testimony in order to remove a child from their parent, and a different standard, which I'll get to a little later. So best practice is, can I use it now? Yeah. Is for the court to wait to hear back from all the tribes until the 60-day period has passed. So you've got your green receipts. They were signed, stamped July 1st, and you're in August, and you want to proceed with disposition, and it's a Cherokee case. You've heard back from the Bureau of Indian Affairs, the Secretary of Interior, SOI, the Cherokee Nation, and the Eastern Band of Cherokee Indians. However, the third band that I mentioned earlier, the United ICWA Band of Cherokee Indians, has not yet responded. So we're waiting. We don't know. Maybe this child is a member or eligible for membership in the United ICWA Band of Cherokee Indians. But the court doesn't know. If we keep going and 60 days have passed and we never hear from the United ICWA Band of Cherokee Indians, the court can say at that point, this is not an ICWA case. I'm going to make a determination that ICWA does not apply to this case, and we will go forward from there as if it were any other case. That's why we wait the 60 days, because it can create a whole mess of problems if you try and go forward before the 60 days, requiring the higher burden of proof, the qualified expert witness, and it's not actually an ICWA case. If after the 60 days it turns out to not be an ICWA case, then you've kind of created a little bit of a dilemma there. Sorry, I skipped a slide, so I'm just making sure that I got everything. Now, I also included in there the Rule of Court 5.482D2 and 3, which indicated that the court is not required to delay proceedings for a response, but must apply the substantive provisions. That's working in tandem with 5.482D1 that gives you the 60 days. So just as a matter of practice, if it's in your court, the child has not been determined to be eligible yet, but there's been an indication that this child may be an Indian child, we must urge the court to wait the 10 days before going to juris and wait the 60 days before going to dispo. And I know that that may be hard for a lot of your clients, but if it turns out that this child is an Indian child and the tribes are just a little slow in responding because, as I said, they get numerous notices sent to them, you can imagine, and you go forward and waive that right, you've waived this wonderful opportunity for your client that could be laying out there that may mean that their child doesn't get removed from them under the higher ICWA standard. Okay. Oh, the one other caveat that is on the slide that I skipped, it's a really nice little important one, especially if you really need a continuance, is that in any case that you're still waiting for responses or it's been determined it's an ICWA case, if a parent, Indian custodian, or tribe requested a continuance of up to 20 days, must be granted. It's non-negotiable. If it's requested, they have to give it to you. So that's a nice little thing to have in your back pocket if you need a little time on juris and your court's pushing you to go forward and this may be an ICWA case. You do have an automatic right to up to a 20-day continuance in that matter.
Is that under that same California rules of court?
Yes. It's on this notice timeline slide, and it is the second part of California Rules of Court 5.482A. Can I just X that? Okay. Now, all these notice timelines and rules I've talked to you about do not apply at detention. They are supposed to immediately, upon discovering that a child may be an Indian child, send out notice, even for detention hearings, and they are supposed to provide proof of it within 10 days of the detention hearing. However, it often is up to us at the detention hearing to even notify the court of a potential Indian child Welfare Act case. So that is, in a nutshell, I know I talked really fast, I'm sorry, I was a little nervous. So that is, in a nutshell, notice. And before I continue on, I'm going to open it up to questions on notice. And I have a lot of other information to provide. Go ahead.
I just have a question about the ICWA 020. How do you handle it when a client says, I might have heritage, but I don't know anything about it? You just say I may have Indian ancestry and leave it blank?
So you're my client. You said I might have Indian heritage. I ask you, do you have any idea what the tribe is?
No.
Do you have any family members who might